All right, this is just We the People News. One more time at it. Educational purposes only. Okay. I'm not an attorney, not giving legal advice. All right. Anything I say to do is my opinion or my commentary. Okay. So, just to be clear, I'm not an attorney. All right. Never look straight forward. Always look straight forward. Never look straight forward. Always look around you. Be able to protect yourself by any means necessary. All right. Use that Second Amendment. Arm yourself with knowledge. All right, so this is going to be part two of one of my favorite court cases. All right, and this is Kirk's. All right, this is from where the storm clouds are gathering. Okay, let's see if we can get a better picture of that. There you go. All right, and back up. And again, my favorite is towards the end. Now, to be clear, people have told me, well, he said he has a jury of 12, but the judge won't allow him for 12, only 6. People had commented a couple of years ago on this. And so, well, no, you don't have to. Well, this is a criminal case. It's got to be 12, not 6. 6 could be in a lower form, but allegedly, I still don't even believe that should be even lawful. All right, but you'll see what he's talking about at the end of this. But remember, this is still administrative. This is all contract. This is where plea bargains happen and this, that, here, and there. Your driver's license, because it's contract. Everything that they're forcing us into contract, which, I guess they're allowed to do. But the enforcement and to mislead you into all these things is what is unclean hands and unlawful to mislead us. All right. Let's see here. We'll go from the back. All right, let's go.
For status as well. Mr. Pendergrass, can you hear me? I see your name's been there for a while.
Yes, sir, I'm here.
Thank you very much. We're set for trial in your case tomorrow. I know we have a few things. I saw a verified motion in limine from last Friday that we'll have the parties address in a moment. Is the state prepared for trial tomorrow?
Yes, it is, Judge.
Mr. Pendergrass, are you?
Yes.
Okay. One thing I want to take up before I talk about anything more. A while back, I'd appointed standby counsel from the Public Defender's Office. For me, what that means, and I'm going to talk and make sure that's what you want, Mr. Pendergrass. Standby counsel for me means they're in the back of the courtroom on one of the benches. They're there to consult with you if you need it during the trial, but you're not required to do so. They have not prepared the case, but they're a resource for you. Do you wish that to continue?
I never asked for that to begin with, so.
I know. I did it one day when you weren't answering questions. I did that. I'm happy to relieve them, but if you want them, I'll leave them there.
I do not want them.
Okay. The Public Defender's Office is relieved from appearing as standby counsel. I'll unappoint them. Mr. Pendergrass will proceed self-represented in this case. Do you want to take up your motion in limine, Mr. Pendergrass? I've read through that. That was filed on Friday, and I'm happy to have you argue that to me.
Absolutely. Is there an objection to it?
I'll hear from your points, then I'll ask the state as soon as you argue it.
Well, if there's no objection, then it has to be granted.
Mr. Haylett, do you object to it?
Your Honor, the state objects.
Go ahead, Mr. Pendergrass.
What are the grounds for objection?
If you'll tell us your argument, you also filed it in insufficient time, so if you'll please give your argument, then I'll have the state address their objection.
Well, the argument is there was no criminal complaint filed, no adjudicated facts, so there's no facts to support any claim of any kind of lawful arrest to begin with. So we have unsubstantiated claims. So truth cannot become fact without evidence. And pursuant to the rules of evidence, you got to have the evidence. So there is no evidence. So the man can't talk about something that doesn't exist. I mean, this is fundamentally and principally here.
Typically, evidence comes into trial through testimony. And so tomorrow there would be evidence. Will you respond to that, please, Mr. Pendergrass?
But what evidence are they going to submit of an adjudicated fact of a lawful arrest? or a lawful investigation.
I don't know what I'll be hearing tomorrow. I'll be hearing it with the jury tomorrow.
That would be the plaintiff's duty there to submit that to me, and there is nothing. I'm stating right now for a fact there was no criminal complaint filed. There's no adjudicated fact. We're well past a year's timeline for any kind of a misdemeanor.
In regard to the traffic related allegations.
Any of them. None of them. Prosecutor never filed anything. There's nothing ever been filed. There's no crime, no nothing.
Okay. Go ahead. Anything else you'd like to say, Mr. Pendergrass?
Well, that it would severely prejudice me as well as be misleading to the jury to allow hearsay. Those are the grounds to limit this from being presented. So my request and my demand is that he be limited, the one witness they had, to be limited from speaking anything about any kind of probable cause for what he allegedly pulled me over for, because the prosecutor never filed anything. There's no complaints, no adjudicated fact, and again, we are well past the 1 year mark for any kind of a misdemeanor. Nothing's ever been filed.
Okay. There was a formal complaint.
Now, that being said, y'all, for the subject matter jurisdiction to get a personal jurisdiction, there has to be a victim. Where's the victim? And this is what he's standing on. Who's the complainant? Who's the victim?
With the resisting obstructing. That was
No, excuse me. Objection. I'm talking about to support a resisting a lawful arrest. Because
there was no
resisting.
No, sorry, I'm pausing to get in the middle of this, right? There has to be a first-degree charge. There has to be a victim. All this other stuff they're bringing up is a secondary charge. Where's the first-degree charge to give the probable cause? Where's the victim?
In a lawful arrest, you have to prove that there was a lawful arrest being made first. So where's the adjudicated fact of a lawful arrest being made first?
I understand your position on that. I understand the point you're making. There was a formal complaint. You said there was no formal complaint filed. I want to simply clarify there was one for this charge, this trial, not for any traffic-related offense, but for the resisting or obstructing. There was one filed on November 2nd of 2022. Any additional arguments you want to make, Mr. Pendergrass?
That this is all fraud. It's also fraud upon the court, which it was in my motion to dismiss, which you disregarded. The fact is there's no grand jury indictment here. The state of Idaho cannot be the injured party. They're not a real party in interest. It's a fiction. Okay, where's my accuser? I have the right to face my accuser. This is what is the nature and the cause of action here? Where's the accuser? Is the accuser going to take the stand? That's grounds for dismissal right there. No grand jury indictment, grounds for dismissal. All these things that are lawfully supposed to be done following due process of law and the law itself hasn't been followed. So we've got deprivation of rights, fraud upon the court, the judicial machinery itself. There was no initial appearance. It wasn't taken before a magistrate immediately.
I'm going to stop you because we're dealing with your motion in limine. Those are issues that have already been adjudicated. So I'm referring specifically to your motion in limine only. Anything else in regards to that? You brought up hearsay that wasn't included. You included rules 401, 402, and 403. Nothing under Chapter 8 of the Rules of Evidence. So this is something new you addressed. Anything else in relation to
Rule 901?
You wrote Rule 901.
There's no documented proof.
Particularly relates to self-authenticating of documents. You did raise that, and I acknowledge that as well. Anything else in relation to your motion that you filed?
Yeah, just reiterating that it's unfair prejudice. It would confuse the issues. It would mislead the jury. And there's no evidence to support any of those facts, that there was anything.
Thank you very much. Mr. Haylett, the state's response.
Your Honor, the state would object to this motion in limine. All of the evidence referenced by Mr. Pendergrass does fall within the relevancy and materiality contemplated within Rules 401, 402, and 403. And all of that will be addressed with the testimony of the officer to be presented tomorrow.
Thank you. Anything else from the state?
Nothing further, Your Honor.
The court has read through the briefing made by Mr. Pendergrass. I've reviewed rules 401, 402, 403. 401 is the test for relevant evidence. 402 of rules of evidence is general admissibility of relevant evidence. And 403 is excluding relevant evidence for prejudice, confusion, waste of time, or other reasons. 901 that was referenced relates to the I'm going to make sure I give the exact title of this. It's generally within the authentication rules, but relates to authenticating or identifying evidence. In this case, for resisting and obstructing, 3 important elements have to be proven. 1, that a person who was resisted, delayed, or obstructed was a law enforcement officer. 2, that a person knew they were a law enforcement officer. And number 3, the defendant also knew at the time of the resistance that the officer was attempting to perform some official act or duty. I'm referencing Idaho Code 18705 as well as a multitude of case law from the state of Idaho on that. In the court's perspective, context often matters in a criminal jury trial, especially in matters such as this, where an order from an officer has to be in the performance of some official act or duty. The court finds that a traffic stop leading to this is relevant to discuss whether the officer is performing some official act or duty.
Objection. There's no adjudicated fact of a
Sir,
lawfully.
Sir, stop. It's my turn. I'm ruling now. I understand you disagree.
I'm objecting to your entering facts on the record that are not in evidence.
So far, I have not
There's
heard
no
that.
adjudicated facts.
I agree with you. There's been no adjudicated facts. I agree with you. What I've heard is argument in the past. Your argument, your verified filings that were done earlier that indicated you were stopped for a certain reason in traffic, which led to this. And so I find that a traffic stop is relevant to whether the officer is performing some official act or duty. An officer's duty includes only the lawful and authorized acts of a public officer. We'll be hearing about those tomorrow. I expect evidence will be given at trial. If it's not, then it'll be right for a motion for judgment of acquittal when the state rests. In this case, a traffic stop is relevant in the court.
Okay, now, understand this clearly. We are starting to wake up. We the people. Okay? Not we the person. We the people are starting to wake up. So there is case law about the traffic thing. Okay? But when you start reading into the statutory construction of all this charges, when these attorneys argue with another attorneys, with judges that coerce one another into these judges, there's been case laws saying it. But all these case laws is still in the realm of commercial. And yes, they do have that. And the case laws do apply to that. But we got to create new case law for the people that's not in commerce. Right? So this is the issue we're having today. Right? We got to get the courts to kind of reevaluate. There's been court cases out there saying you don't have to have all these things. And yet, they are ignoring it. And yet, people are out there convinced it does not exist. And yet, they keep doing the same thing over and over and over and violate whose rights? Yours. And they want you to be ignorant of your rights. So, I know that he... who was fighting this, so he was suing them in federal court eventually. So I don't know what become of, if he won the lawsuit or anything like that. But anyway, I know that that has occurred, if he's still in that process today of the suit or not. When you get into real rights and standing on your real rights, courts don't like it. And it takes longer to fight for your real rights than it is for you to comply in your non-rights.
Yeah, to whether the officer was acting as pursuant to his duties and engaged in lawful and authorized acts of a public officer. It gives the jury a basis under which the officer was attempting to perform any alleged duties. It's beyond dispute, and I'll quote State v. Hallenbach, 141 Idaho 596, pages 599 through 600, a Court of Appeals decision from 2005. It's beyond dispute that during a traffic stop, an officer has the authority to control the movement of the driver of the stopped vehicle. and they have certain rights and duties that they can perform during that. Also referencing Pennsylvania versus Mims 434, United States 106, a Supreme Court case from United States Supreme Court case from 1977. There is context that can be given. I understand the point that you referenced. This is not relevant, but the court finds it's extremely relevant in terms of whether the officer was performing some official act of duty. Rule 403, the court may exclude relevant evidence if its probative value is substantially outweighed by danger of one or more of the following. And you've raised some of these: unfair prejudice, confusing issues, misleading the jury, undue delay, wasting time, or needlessly presenting cumulative evidence. The court may, it's discretionary in nature. The test is whether it substantially outweighs, the probative value is substantially outweighed by one of those. And the limited information I have, I find that it's not. Quite frankly, this is your motion, your burden to carry. You haven't given me sufficient basis to carry it. And so I'm finding that under 403, it's proper to give it. Now, the court tomorrow, when we hear evidence, can give a living instruction pursuant to Rule 105 if that is proper. I don't know if it will be until we hear that, and I'm certainly happy to address that with the parties if they find limiting the evidence to whether the officer was engaged in the lawful performance of a duty, and that the jury shouldn't consider the nature of whether you were registered, not registered, or something else to that effect. So I'm denying your motion, finding it to be improper in this situation. Most of the things we've addressed as well: grand jury indictments, facing the accuser, other things, deprivation of rights, been addressed previously. The court stands by its decision. You always have appellate rights in regards to that.
And we're going to pause right there, right? And this is the problem we have been tricked into, y'all. During the beginning of the video, he says the nature and the cause. Well, he's bringing up all the natures, but he's never clarified where the cause is, right? Because in order to be a cause is the injured party. Who's the injured party? He's going back with case laws, Pennsylvania versus Mims. Okay, that doesn't apply to your rights of free movement. It does apply to commercial entities. Okay, and you guys can argue this all you want, but until you actually study in there and do statutory construction instead of just reading the statute, but break it down, look up every single definition of what all these words mean, don't argue about it.
We are set for trial tomorrow, and I plan to go to trial tomorrow. The trial will begin at 8:15 a.m. We'll take up jury instructions. I will have those for the parties at that time, pre-proof jury instructions, and I'll have post-proof, the instructions that I prepared in anticipation if we make it through to the end of the day. We'll take those up. We'll also discuss jury selection. I typically give the parties 20 minutes each for jury selection, pursuant to Criminal Rule 24, governed by the court. Each side will have 4 peremptory challenges that they can exercise. If the parties in consecutive order waive peremptories, if Mr. Haylett waives the peremptory and then Mr. Pendergrass, or if Mr. Pendergrass waives then Mr. Haylett, that will be a waiver of any additional peremptories. So if you wish to utilize them, please do so. 4 is the allotted number for peremptories here. This will be a jury of 6 persons.
Objection. Right to trial by juries of 12 men of my peers, without whose unanimous consent cannot be found guilty.
Understood.
That's the law.
This will be 6 jurors tomorrow.
Objection. That's deprivation of the right to a trial by jury.
Understand your request. It's denied.
It's not a request. It's the law. You're not following the law. You're in breach of your oath of office. You're committing felonies, which is treason. So I'm accusing you of committing treason on the stand in open court.
Denied.
Now, just for clarification right there, right? So again, that judge is going into administrative contract laws. Kirk is going in common law, a trial by jury, not jury trial, but trial by jury, which is our law of the land in the United States of America, people. Quit letting these idiots control you like little puppets. It's not complicated.
I'm not.
You don't get to deny that. I'm accusing you.
You can say what you want, Mr. Pendergrass. It doesn't make it true, or factual, or reality. That is what will be happening tomorrow. Which witnesses does the state intend to call tomorrow?
Your Honor, the state plans to call Garden City Police Officer Bryden Wiggins.
Is that the only witness?
Yes, Your Honor.
Mr. Pendergrass, who are you calling tomorrow?